Okay, so today what we're going to do is I want to ask a couple of questions as refresher questions from the material that we covered last week, and then I'm going to get into the new material. So we have a little bit to catch up from the syllabus, from the things that were supposed to be done last week, and then we'll get into this week's lectures. So last week we spoke about the burden of proof when it comes to criminal matters and when it comes to civil matters. Who can remind us what the standard of proof is in a civil matter?
51%.
51%. Do you remember the name of what it's called? 4 words.
I know it was
Preponderance.
Yep, preponderance of the evidence, exactly. So whenever like I said, I always test on criminal and civil on the exam, so make sure you know this. So the civil burden in a case is preponderance of the evidence. Preponderance of the evidence. And if you were to equate that to a number line from 1 to 100, it's basically about that 51%. More likely than not that the plaintiff or the person who's bringing the action is telling the truth. So then that's, they would win their case as long as they can show more likely than not that their version of the event is correct. And so again, the title is preponderance of the evidence. We also spoke about, I believe we spoke about, whenever we have a lawsuit, right, in a civil case, we have these 5 elements that must be there. They must be present in order for a plaintiff, a person bringing that lawsuit, to be successful. I don't think we went over it in detail, but I just gave you the words. Who could tell us what those 5 elements are? Duties 1, good.
There's breach.
Breach, good.
Proximate cause.
Proximate cause, good.
Actual cause.
Actual cause, and the last one.
Damages.
Excellent. Very, very good. So you need to have all 5 in order to have a successful or, basically just meet the minimum in order to now, prove your case. We do have a guest with us this evening. I'm going to introduce him because he's been very excited about this class. This is my son, Christopher. He's 8 years old. Since COVID started, he has heard these lectures. So he's heard these lectures like twice, and he wants to be able to answer questions when I do ask them if he knows the answer. So I may pick on him. If nobody knows and he has his hand up, number one, you should feel ashamed. But if he knows it as an 8-year-old, then, I will pick on him. He may be able to help you. So Christopher, say hi.
Hello.
Hello, Christopher.
They're saying hi back. They're all saying hi back, but you can't hear them because I'm on this thing. But so you can go back to your reading and do whatever you want. And the little guy, the 4-year-old, is actually sleeping. So he slept in the car, ching ching, so you won't hear him tonight. Okay, so now we're going to go over the 5 elements. I want to make sure I did not go over them to explain them in detail, right? Last time?
Correct.
Correct. Excellent. Okay. So whenever we talk about the elements of like the elements in any plaintiff case, we talk about these 5 things. I'm going to go over them briefly now, and then I want to get into a couple of different cases, and then there's actually a chapter dedicated to them. One of the chapters that's coming up, but I do want to give you a little bit of an explanation so you know what these things are. So when we talk about duty is the relationship between the 2 people that have now sued one another. Duty, there's actually a lot of different relationships where a duty exists. Duty can exist between a driver on the road and a pedestrian. So for example, a driver on the road has a duty to a pedestrian not to run them over. Okay, you have a duty to be careful on the road. A teacher in an elementary school has a duty to her students who are minors. Remember that example I gave you about, if somebody was having that allergic reaction? And I don't actually have a duty to protect those students. Why? Because as a college professor dealing with adults over the age of 18, I don't have a duty to you. I don't have to protect you. I don't have to, save your life if I don't want to. I don't have that duty. So there's different relationships that exist. A landlord may have a duty to a tenant. A doctor has a duty to a patient. So when we talk about duty, the court analyzes, or the law analyzes, the relationship between the individuals. Was there a duty owed from one person to another? Now that brings us back into the next element, which is breach. So if there's a lawsuit, the plaintiff is saying that, hey, there was a duty from this person to me, and that duty was breached. They didn't do what they were supposed to do. Get it? No, go. So now the breach of that duty is that next element. So the doctor was supposed to operate on my left leg, but instead they actually operated on my right leg. There's a breach. They didn't do what they were supposed to do. Okay, we're going to stick with that example for a second. Next element is actual causation. Actual causation is the actual problem, the actual, breach taking place. So in that example I just gave you about the doctor operating on the wrong leg, the actual physical manifestation of the doctor operating on the wrong leg is the actual cause of the harm done. So the doctor did something wrong. There was a duty. He breached that duty. He wasn't careful when he decided, which leg he was going to mark up. And instead of putting an X, they put an O, and that's why this actually happened. This is an actual cases. These things happen. And so there was an actual cause. There was an actual problem. If we talk about it with a car accident, a car hit another car, or a driver hit a pedestrian. The actual causation, the actual incident happening. Proximate cause is proximate cause is a little bit more difficult to understand from a legal perspective, but the best way I could explain it is the but for, B-U-T space for. But for the car hitting the pedestrian, there would have been no accident. So it's a but for it's like the foreseeability. Was it foreseeable that this accident was going to happen if the facts were not lined up? Again, I'm going to save the proximate cause because there's an excellent case that talks about it when we get to proximate cause. But just out of the 5, proximate cause is the most difficult concept to understand, but you'll get it. You'll be fine.
Professor?
Yes, sir.
Sorry to cut you off. So like an easier way of understanding proximate cause is like, could it have been prevented? Not
so much could it have been prevented, but was it foreseeable that this was going to happen? And if it was, were you able to predict that this would happen if the facts are all the same? Or, if I give you a fact pattern and I tell you the conclusion, you would be like, oh, there's no way I would have guessed that would have happened. And so you need proximate cause, the fact that it was foreseeable that an injury like that would happen, in order for it to be one of those 5 elements and for the plaintiff to have a successful outcome. Brian, I see. Thank you.
Thank you.
By the way, Nicholas Della Pioli, do you have an attorney in your family? Because there's a Della Pioli attorney.
Yes, Eddie.
Yes, Eddie.
Yeah,
Della.
that's my grandpa's cousin. Yeah.
And grandpa's cousin. All right, because I saw that name and I was like, that name sounds familiar. It's Staten Island. Staten Island.
Yeah. Every time I'm on the island, everyone brings that up to me.
Yes, too. I couldn't help myself. Okay, Brian, I see your little yellow hand is up. I don't know if it's for.
Yeah, I just think
Sure.
my internet acting sketchy because it's pouring outside and the lights keep flickering. So if I like disappear and come back, that's probably because my internet died or the
okay. Okay. Well, thanks for letting me know. Okay. So now we did 4 elements. The last one is damages. There has to be some kind of harm caused in order for you to sue for something. So I remember, I'm going to give you this example. So this is real life. So I was driving one day, I don't remember when it was, a couple of years ago, and somebody like behind me tapped my car, right? He hit the car. And so there was a couple of scratches or whatever, right? So then, we exchanged information and whatnot. And then I'm telling my mom, and she's like, my mom's funny. So my mom was like, you have to sue. And this is with the Arabic accent, why you don't sue? Why you don't get lots of, I was like, Mom, there's no damages. This is a scratch. This is not something where I'm going to be able to collect money. Like everybody thinks, you can sue for anything, you're going to become a millionaire. Well, number one, you can sue for pretty much anything. But what you have to realize is you may not get anything, right? So you have to have merit to the case. There has to be those 5 elements. There has to be damages. The wrong leg has to be cut off. There has to be, a hit and run or like a hit and damages incurred from a doctor to a patient, or from a car accident to a pedestrian, or a building falling. There's got to be damages. If those first 4 elements actually took place, but nobody got hurt and, nothing happened, what are you suing for? Don't tell me the emotional distress. Don't give me that, right? Because if you have emotional distress, you really need to have a physical manifestation of it. You're not going to be able to just sue on, I was distraught, and, I was fearing for my life. That is an actual legitimate cause of action, but there has to be something else with it. It's not going to be alone and you're going to be successful. Okay. We're going to go into more detail, more examples later on, but now I wanted you to have that framework. Does anybody have any questions before I ask about the next case, which is on your syllabus, which is a case I want you to know?
I do have a quick question.
Sure. Go ahead, Liam.
So if you think about the but for the proximate cause one, so if you take the medical example, because you think about it like, well, the foreseeable future was that he was going to operate on the proper leg, but then he didn't. So that's an unforeseeable thing.
Like it's, I guess it's foreseeable that when I give you that case, Paul's Graph versus Long Island Railroad, it'll really click home about the foreseeability, because you can speculate and you can guess as to whether or not things can happen, right? We can guess, if the operating room, lights and energy and all the, their blah, blah, blah shut down. And then as he was about to operate and then he operated on the wrong leg, was that foreseeable? No. And so there would be no negligence in that respect. But if he simply, marked the wrong leg, it's hard to explain it without me using that particular case.
Right.
Not so much circumstantial, because circumstantial evidence is really used when, when you're trying to prove something, but the proximate cause, it's linking the events together and then you're trying to show the jury, or you're trying to show the judge that, this is a proper sequence of events that, but for, the doctor not paying attention, or but for the doctor marking an X instead of an O, this wouldn't have happened. And so by him doing that wrong action, that's why you have that result. But the foreseeability, or the but for, would we have imagined that a tornado would have picked up the hospital and spun him around or something, or a bee went into the operating room? Foreseeability is like a weird concept, but again, and I know it's the most difficult one out of those 5, but bear with me. Later on tonight, it's gonna click. It's gonna click. So with that being said, who wants to tell us about the case which is on the syllabus, which I expect you to know, which is Philip Morris versus Williams? Are you sure you know about that one? I know you know White versus Samsung. I might call you on for that one, but let me give the class a chance. So Philip Morris versus Williams. Now, this is a case, and I believe I mentioned this, first class. If I don't have any volunteers and nobody talks about the case, then I automatically test on it and I don't go into it. I'm not going to discuss it, because the only thing you have to do for this class is read. There's no other assignments. There's nothing. There's no quizzes. There's no written assignments. It's just reading and being prepared for class. So again, I ask, who wants to tell us about Philip Morris versus Williams? A hand is raised and the class is saved. Jessica, go ahead.
So basically it was in the event of the death of Jesse Williams, who was smoking cigarettes because he believed that it was safe to do so. So his family sued the Philip Morris manufacturing company, which worked with Marlboro cigarettes, and they ended up getting a payout of 79.5 million, which was then, I don't know if it was like retried or if it was
Appeal.
appealed, yeah, as you know, overly excessive for the damages ensued.
And then do you remember what happened?
It was reversed so that they did get the 79.5 million.
So it was appealed, and then it was, I don't remember if there was a reversal and then another appeal, but they were ultimately affirmed.
Right.
Right. Does that make sense? Listen, for as far FYI, for my class, you don't need to know. I'm not going to ever test you on reversals, appeals, lower court, higher court outcome. I just need you to really understand. Thank you for the reminder for the attendance. I just really need you to understand the legal concept. Jessica, I'm going to ask you another question. You've saved your class, you know, with this particular case. What if there was there was an excessive outcome, right? 79 point something, you know, $1 million. Do you remember why the court affixed that, or why the court did that and said it was okay? There's a particular word that I want you to say. It starts with the letter P, if I'm giving hints.
Punitive damages?
Yes. Yes. Punitive damages. So this case, the concept of this case, the idea behind this case is the assessment of punitive damages. Now, if you want to remember, I like, you know, mnemonic devices. If you are going to associate punitive damages with another word that maybe is a little bit more familiar to you, what would that word be? Do you know what, Christopher? No, okay, fine. It also starts with a P. P-U. What are they doing to Philip Morris? What were they trying to do to Philip Morris, and what were they trying to do to all the cigarette companies?
Punishment?
Punish them. Punish them. Punitive damages, when you hear the word punitive damages, I want you to think of the word punishment, because that's what was being done. It was excessive. Was this man's life worth $79.5 million? It was done as a way to send a signal to all the tobacco companies as a way of punishment. And if you look at the history of this case, this isn't a particularly old case. Right? I remember, and I'm older than you, growing up when I was, you know, in elementary school, I guess, I remember seeing commercials for Camel, for Marlboro. They would be advertising on TV all the time. Like that was a normal thing. As a matter of fact, my dad, super heavy smoker. My dad smoked Marlboro Lights, as he liked to you know, to emphasize. And so with Marlboro, if we were in real class, I'd ask if anybody actually has a cigarette packet with Marlboro. The side of the cigarette box, it had like these kind of like reward points. Okay, it was reward points. And my dad was such a heavy smoker. We had tons of stuff from Marlboro. He had winter jackets. He had like pens, and he had a canoe. We had a canoe that had Marlboro plastered on the side of it. All right. So tons and tons. I mean, my dad has, you know, he quit smoking a long time ago. Thank God for that. But those were things that are no longer done, right? You don't see the advertising of cigarettes on television. And what you also see on cigarette boxes, if anybody has a cigarette box that they'd like to show the little screen, what do cigarette boxes have on them now? That's in nice big bold letters. Christopher's raising his hand, so I'm going to let Christopher give him an opportunity. Yes, you said it, Brian.
We have these giant
Smoking kills.
bulging warning signs telling you that you can die if you have too much of these.
See?
So that is why I don't,
Smoking is bad.
and I will never smoke a cigarette.
Excellent.
Plus, it causes pollution.
Thank you, Christopher. So that's what you have, right? So the cigarette box says, this boy is going to be something one day, I'm telling you. You have on the smoking cigarette boxes the warnings. It can kill you. The Surgeon General's warnings that it can, don't smoke if you're pregnant. It has all that stuff in huge, huge letters. Why? Because of this particular case, right? $79.9 million or 79.2, whatever it was. All right. Jessica, great job. I'm going to now take attendance. We do have, it looks like almost a full class. When I'm going to have my Excel spreadsheet up. So when I say your name, you need to verbally acknowledge you are here. I need you to say the words. Okay. Muhammad Abdullah.
I'm here.
Ezra Afane.
I'm here.
Great. Hilal Ahmed.
Yes, I'm here.
Excellent. Sean Bansal.
Here.
Great. Gregory Bartocci.
Hi, I'm here.
Great. Shpetam Barisha. Harun Bhatti.
Here.
Great. Matthew Barres.
Here.
Okay, great. Elizabeth
Shvetam said he
Castillo.
was here in the chat.
Wait, who said that?
Shvetam said he was here in the chat.
Oh, he did. Okay, thank you. Elizabeth Castillo. Elizabeth Castillo. Okay. Chaz Chambliss.
Hi, I'm here.
Great. Franklin Chan.
I'm here.
Great. Hugh Hua Chen Wu.
Here.
Great. Yuki Chiba.
Here.
Okay, great. Aurelis Chow.
Here.
Great. Francis Calusawano.
Here.
Okay, great. Heavenly Daza. Nick DiPioli, I know you're here because we had the whole name discussion. Timothy DiPaolo.
Here.
Great. Brianna Diaz.
Here.
Great. Dukerson Duze.
I'm here. I'm here.
Okay, thank you.
Yeah.
Fadi Pham.
I'm here, Professor.
Great. Jessica, I know you're here. Naomi Francis. Christina Frizone. Nicholas Philip Gazillo.
Here.
Okay, great. Jiamen He.
Right here.
Okay, great. Vanessa Home.
Here.
Okay, great. Dawood Janda.
Here.
Great. Michelle Collison.
Here.
Ina Korban.
Here.
Okay, great. Marvin Matthew.
Here.
Okay, great. Liam Henry McMillan.
Here.
Okay. Destiny Miller.
Here. I have a question also about weight.
Okay. What do you have a question about?
The textbook I had emailed you, but you never got back to me. I sent you a link. Actually,
I don't check my CSI email that often. I think I had given my Gmail last week. So if you wanna, I'll check it today afterwards, but let me put my email in the chat now
Yeah, thank
because
you.
that's probably, that goes to my phone. So I check it at all times. Okay. But the textbook is on the syllabus. So, I mean, if it's the same thing, it should be fine. Joey Natale.
Here.
Letitia Linnell Negron.
Here.
Vincent Palazzo. Vincent, are you here? Brian Portnoy, I know, I think you spoke today.
Yeah, I'm here.
Okay. Litram Ramadani.
Yeah, I'm here.
Okay. David Riyad. David, is that you? Okay. Take that. Compton Richmond.
Yeah, Professor.
Gotcha. Melissa Ruggiero. What is that beeping sound I keep hearing? Is that like people? Hold on. Melissa Ruggiero, is that you beeping or something? Melissa, hello. Pietro Arthur Scarso.
Here.
Thank you. Taneria Lynette Scott.
Here.
Okay, great. Vebi Trumick.
Here.
Okay, great. Kana Kar Wahid Zuzaman.
I'm here.
Great. Edward Ramos.
Here, Professor.
Great. Ivana Romprup.
I'm here.
Great. Anthony Brodsky.
Here.
Okay, got it. So we're good for tonight, and we're gonna move right along. Okay, so next case that's on your syllabus is.
I don't think I heard my name.
Oh, okay. I'm sorry. What's your name?
Should be on the G. Matthew Lewis.
Matthew Lewis.
Yeah. Spelled differently.
Did you register late?
Like I'd say last Tuesday maybe.
And you weren't. I don't have you as being here last week either.
Yeah, because
You weren't here. Okay, so I'm gonna have to. I'll have to check you. Spell your last name for me.
Louis.
Yes, and your first name is Matthew.
Jean.
Jean.
Yeah. Matthew will be like the middle.
Okay. John Lewis Matthew. Okay. Yeah, I definitely don't have that. So you're here today. And we were here last week. Okay. For the people, I know you're not the only one that missed the first class. I will this weekend post last week's lecture also, maybe even a little bit before. You have to make sure you watch that video because I talk about the policies of this class. And we talked about criminal law, and that's also I put that on the test a lot, and we talk about the exams and all that good stuff. So just make sure you catch up on that. All right. So is there anybody else I didn't call? Okay. So next case. Let me go back to that chapter. So when we talk about intentional torts, there are some torts, and a tort is basically, you know, an accident of some sort, or it's a type of negligence. Okay. There are torts where elements of, you know, compensating people who got injured and preventing future harm, that's all falls under the whole, you know, negligence, you know, section of the law. But there's also, you know, battery. That could also be considered a civil case, not just a criminal case. And when we talk about battery, it's the intentional infliction of harm or offensive bodily contact. What's interesting is I think the definition of battery, or what people may find offensive, has changed over time. So it's offensive if it would offend a reasonable person's sense of dignity. If you were to talk to me 2 years ago, before COVID, and, you know, we were talking about battery and we were in class, and I say, you know, like if I tap somebody on the shoulder, if I cough or if I sneeze, right, in class or near somebody, we wouldn't think everybody bless you, bless you, bless you. But now, if you touch someone, if you sneeze, it's like you have the plague, right? People will look at you funny now because of what's happened in the world over the past year and a half. So is it considered battery Is it offensive to people if you touch them, right? Where it could have been perceived as normal, okay. Look at also what has happened with, the governor, right? Governor of New York. He thinks everything he did was fine, hunky-dory, nothing wrong with it. People, people that worked with him absolutely say differently. So battery, and when you talk about, and I see, Leitrim, I see your hand up. Give me 1 second. When we talk about battery in the civil sense, you're talking about somebody who's asking for monetary compensation for that particular issue. When we talk about battery in the criminal sense is somebody trying to put somebody in jail or prison because of, the harm suffered. So it could have two different components. Go ahead, Leitrim. Am I butchering your name?
That's fine. I'm used to it.
I'm sorry.
That's fine.
Say it for me. Say it for me. Maybe one day I'll remember it.
Lutrum.
Lutrum. Okay, I should be able to. Lutrum. Okay, go ahead.
Yeah. I don't know. I feel like last year I saw an article of a lady sneezing on a baby.
Oh.
And this was like during COVID. And
I
think they charged her with like bioterrorism or something like that. Something crazy.
There was a person that was going in the grocery stores and coughing on fruit. I don't know if it was the baby or the fruits and vegetables.
Yeah. No, that's a different one, but I heard about that too.
Yeah. So, the issue is, hold on, I'm just looking at messages now. Devontae Garway, did you speak up? No, you didn't. You got to speak up, Devontae. I didn't call your name because you're not in the class. Okay. Hold on 1 second. So at that time when COVID was, still new, what could be offensive to one person has changed over time. Was it bioterrorism? I don't know if that was a successful case. You could be charged with it, whether or not you're going to actually have that as a result. I don't know. Whether or not it's going to stick, I don't know. Is it going to be pleaded down? Probably. So you could be charged with murder. You could be charged with assault. You could be charged with a lot of things, but what actually sticks and what the ADA can prove are very different things. It's going to depend on the elements of the crime and whether or not the intent, the mens rea and actus reus was there.
Yeah, she had intent. She did it on purpose.
On purpose? So yeah,
you can see it on video. The lady literally goes to the baby. I think the mom did something that didn't please her. And then you can literally see her like either sneeze, spit, or something at the baby.
Yeah, that's
something's gonna stick. Something's gonna stick, but bioterrorism is like something.
Bioterrorism may be a little bit like that's, that might be a little too much of a
tactic.
I don't know. Yeah. Okay, Marvin, go ahead.
You said battery in the civil sense, and then the second one was battery in the what
criminal
sense?
Criminal.
All right, thank you.
Yeah, you're welcome. Nicholas, your hand is up.
Yeah, when you were talking about intentional torts, that's only bodily harm, physical harm, or does verbal abuse play into it as well?
Verbal abuse.
Can't they make the argument that verbal abuse can lead to someone causing their own physical harm? Like, I was just curious, so I know what to write down, like easy to remember.
It's so there's been lately a trend in the law to have bullying, right? Bullying be chargeable. But when we talk about things in the civil sense, you're trying to get damages, right? So what are the damages that are going to be, what are the implications as far as damages are concerned to verbal abuse? But with a criminal, sometimes it's easier to actually have verbal abuse because the verbal abuse can result in physical manifestations. And so then it would be easy to charge as a crime as opposed to civil sense, even though the burden is less in civil, if that makes any sense.
I see.
All right. Any other questions before I move on? Because we're behind schedule now. So I'm going to move on actually. So the next case that I want you to know that I always ask about, Christopher, go. False imprisonment, assault, defamation. Oh, I do want to talk about that stuff. Okay. This is stuff I don't usually test on, but just listen, pay attention and learn something. When we talk about false imprisonment, you can't be falsely imprisoned if there's a way for you to get out. So back in the day when we used to be in a physical classroom, I would actually stand in front of the door and block students from going out. And I would give an example and say, if it's 9:30 at night, 10 o'clock at night, and I'm not letting you get out of this door because I'm just so excited about business law and I want to keep teaching you stuff, have I falsely imprisoned you? And then I changed the pattern. The fact pattern, because it depends on whether or not we're on the first floor, whether there's a gigantic window open, whether you can hop out and just get out, or whether we're on a 3rd, 4th, 5th story building and you have no way out except this door that I'm blocking. So when we talk about false imprisonment, not so much as also the physical location, not so much as to whether or not you think you can leave, but also the physical manifestations of the room itself. So that is, false imprisonment. Defamation. So defamation is something actually, I do want you to write this down in case I do test on it. So defamation, you probably heard, libel, oh, that's slander, I'm going to sue you, whenever that happens. When we talk about defamation, think of defamation as an umbrella. Hold on, I want to see if I could. Sometimes I like to use that little feature that they have of that, there's a stupid thing here where you can make a whiteboard. Forget it, I'm gonna use my hands. So think of defamation as an umbrella. Underneath the umbrella of defamation are 2 little branches. One is libel and one is slander. Both of them are considered defamation, but they just have different meaning. When we talk about libel is written, printed, TV, radio. That's libel, written, printed, TV, radio. Slander is spoken, it's oral. So slander is spoken or oral. In order to have a defamation case, you need to have 4 elements. This is all in your textbook. I'm going to go over it quickly, but again, it's in your book. You need to have a false and defamatory statement concerning somebody else. It has to be an unprivileged communication to a third party. If you think it doesn't matter. If you didn't write it down and you didn't send it to somebody and you didn't speak about it to a third party, no. Depending on the state, it could also be considered knowing or failing to ascertain the falsity of a statement. And it's also proof of specific harm. There has to be specific harm suffered in order for you to bring a defamation action. So if somebody says, so-and-so was talking about me and I ended up not getting that job because of the lies they told to this boss or to this other company, well, there's proof of harm there, right? You would have gotten, but for this person defaming you, you would have actually gotten that position, but you have to be able to prove all those elements because again, when you are bringing any type of lawsuit, whether it's intentional tort or regular negligence or anything like that, you have to prove by preponderance of the evidence that your version of the events is more likely than not to be the correct one. Okay. So the next case we're going to talk about is a case that I do want you to know. Let me repeat this again. I do want you to know, and that's the case of White versus Samsung. Okay. So who can tell me about White versus Samsung? Yes, Christopher. Does anybody here besides Christopher want to tell me about, White versus Samsung?
I don't know a lot about it. I know like the basics.
Okay, tell me. I'm gonna let Liam. Hold on one second. You can go ahead, Liam.
Vanna White sued. It's Samsung. Yeah, Samsung for using her likeness in their commercials without paying her for it. They would do things that was very Vanna White-esque without her permission and without paying her for it because they didn't get her permission. So she then sued them for
Damages, money.
damages. Yeah.
Yeah. Now, does everybody know who Vanna White is? All right. Vanna White is not Jeopardy, close. Wheel of Fortune.
Oh, Wheel of Fortune.
Yeah. Wheel of Fortune. She's been around for forever. I feel she hasn't changed one bit in her appearance. And she stands and she points to the letters, you know, and they had a robot that did the same thing. They had a blonde wig, it had a long dress, and it was pointing at letters. And this concept of this case is about what's the legal concept behind this case? Remember, like with Philip Morris, we talked about punitive damages. That was like, hey, that's what this case is about. What would you say that White versus Samsung was about? The legal concept here. It starts with an A.
Assassination of character?
No, but I like that. But no. APP. Yes, Jessica, thank you. Appropriation. Appropriation is what this case is really about. And appropriation is the unauthorized use of another person's name or likeness for one's own benefit. Who are you going to appropriate when you're trying to copy stuff? You're not going to appropriate you, your classmates, myself, right? Because nobody knows us. You're going to appropriate somebody's character that is, you know, well known, you know, a famous, I don't even know who's famous nowadays that young people know that I could give an example of, but like, you know, Brad Pitt. Do people know who that is? Because he's pretty big still, right? Okay, thank you. Obviously, thank you. Yes. So, you know, there are people that are big that you want to appropriate, like Tom Cruise, right? If you had a cartoon character jumping on a couch in front of Oprah Winfrey, right? That's people are going to know that that's Tom Cruise, right? So things of that sort. So appropriation is somebody's famous and you're using their likeness without their permission for your own benefit. All right. So that actually now brings us to completing last week's stuff. And now we're going to start into this week's goodness. Okay, so this week we're going to talk about intellectual property. I'm going to just go through because we have you know, a lot of stuff to cover. Okay, so let me just go back to my notes. La-di-da-di-da. Okay, intellectual property. Intellectual property is trade secrets, right? It's not so much the physical stuff, right? It's brainier things. It could be something like, give me an example. Give me examples of what you think a trade secret would be.
The recipe for Coca-Cola.
Oh, wait, I'm sorry. There's too many people. Lutram, you raised your hand.
Let's say McDonald's Big Mac sauce.
Okay. Yeah, there's a trade secret with that. Good. What else? Restaurant's recipe. Very good. Yep. What else could be intellectual property? Brian.
The software on the iPhones.
Software on the iPhone, right? If it's people don't know what it is, it's intellectual property. Who else has a hand or somebody's writing stuff? Patents, trademarks. Those are all things that are actually intellectual property. Very good. So when we talk about intellectual property, it's a variety of things, right? Intellectual property could be considered trade secrets. It could be a list of clients. There was a case recently where Borgata, I don't know if you're familiar with Atlantic City. So Borgata was actually suing Ocean Casino because what Ocean Casino was doing was taking former employees, higher ups from Borgata who had all these client lists and they were going to Ocean. So there was a lawsuit that those were trade secrets, that those were secrets of Borgata and they should not have been, you know, given away. Trademarks, I think somebody said trademarks, service marks. If I was to give you, now I'm going to try this whiteboard thingy. Wait, no. Whiteboard. Okay. I'm going to make you some symbols, guys, and I want you to tell me what it is that you see. Hold on. What is this a symbol of?
Nike.
Nike, right?
Nike.
Now, I didn't write the word Nike. I just made this check mark, but that was it was a logo of theirs, something that it's not a trade secret. it's a trademark. When you see that, you know what it is. What about, let me see, clear. How about, hold on, bear with me, people. La-di-da-di-da. Something like that. That's not a good drawing.
Is that Louis Vuitton?
Yes, it is. It is. Thank you. Thank you for acknowledging my artistic talent. That was Louis Vuitton right there, right? So I can't make an LV and put it on a t-shirt and sell it as Louis Vuitton, right? That is a trademark of them. Let me see what else I could think of. Oh, here's one. We just mentioned this. I think somebody, okay. Hold on, young people.
Apple.
Thank you. And we're not talking about selling apples, right? What is this apple of what?
Apple Inc.
This is the Apple. Yeah, that's right.
Macintosh.
Thank you. This is the technology, right? This is the technological aspect. So I didn't write Apple. I didn't write the word Apple. I didn't say technology. I didn't write Louis Vuitton bags and purses and luxury items. I didn't write, Nike, but you knew those things. Why? Because their symbols are trademarked. When we have a TM sign, like a little TM next to a particular symbol or something, that is actually a trademark. It's a registered trademark with the USPTO, which is the United States Patent and Trademark Office. And so you can't use that willy-nilly, right? You have to get permission from the organization itself in order to do that. When we see an SM sign, that's a service mark. It relates to a service that's actually also patented in whatever that may be. So service mark, trademark. Now you guys are all knowledgeable about those things. When we talk about a trademark, or when we talk about a service mark, we're mostly trademark, we're talking about a distinctive symbol, right? And when we talk about symbol, I want you to write this down, that it must, I'm going to actually put it in your chat. This, in order for it to be protected, it has to be distinctive and not simply a description of the item. So this is a write it down moment, everyone. I'll put it even in your chat. Hold on, let me make it to everyone. A symbol has to be distinctive and not a description of the item in order for it to be patentable. Right? So for that trademark, it's got to be, and that symbol that you're trying to prevent other people from using, it's got to be a symbol that's distinctive and not a description of the item. Lutram, you have a hand up.
Yeah, isn't the symbol like that C mark?
Copyright.
Yeah.
That's different. So a copyright is also, it depends on what it is. It's also a way to protect a particular item. So it's a copyright. So sometimes there's trademark, sometimes there's a service mark, sometimes there's a copyright, it depending on the item itself that you are trying to protect. Like a copyright is mostly written stuff, like a book is copyrighted. It's a copyright, so you can't, copy a manuscript, things like that. A TM is a trademark, it's that symbol. So I don't know if that makes sense. Look, when you open up a book, right, it has the copyright date when it was actually like, put together like that. You gotta stop. So one of the other things you should know that I want you to know about when we talk about intellectual property, when you overuse a particular branded name item, it actually becomes generic and then it loses its value. So when we talk about, if I was to say to you, hand me a Kleenex. Okay, if we're actually like, face to face, hand me a Kleenex. What would you give me?
A tissue.
A tissue, right? But what is Kleenex?
It's the brand name of
it's the brand name. It's the brand name of a company that makes tissues. What if I was to say, and I learned this, in life, over the past whatever decade or so. Can you give me some Tupperware so I can put my leftovers in it?
Yeah, that definitely. That's the not like Ziploc, but they do have that.
Food container.
It's a food container, but there's an actual brand called Tupperware. So all those plastic containers with lids, those are plastic containers with lids. There's a brand called Tupperware. But what happens is when society uses and normalizes those names, it becomes a generic description. And so then the value of Tupperware, it kind of loses itself, right? Because then it's hard. It's good, you know, in one sense, it's good because now it gives people people, you know what, you know, they've heard the term Tupperware, but it becomes a generic description, and it's harder to enforce your patents against stopping people from using it when it's now become a societal norm, like Xerox, for example. Hey, can you Xerox that for me? It's actually, can you photocopy it for me? Can you make a copy of it? Why? Because Xerox is an actual company. And so what happens is when words like that, brands, are used often in just regular colloquial language, they lose that sense of uniqueness and it becomes attributable to a larger group of products. And so, you know, it could potentially lose its value. Make sense? Let me see what's going on here in the chat. Pampers. Yeah, Pampers is the same thing. Yeah, oh, give me Pampers. Pampers is not, there's a brand. That's a brand, and that's an expensive brand for Pampers, right? You want the Kirkland brand? Kirkland brand is the Costco version, right? So again, it's the same thing. They're diapers. They're diapers, exactly, right? So I'm going to move on. So that's all I want you to know. Let me just look at my notes. That's all I want you to know for intellectual property. Good. We're going to move on to accountant's legal liability. How many of you, because I think I usually get a couple every semester, how many of you are interested in pursuing the profession of accountantness, you know, mathematical people? Lutram. I only see a couple of faces anyway, but Lutram, Ivana, we have, okay, you know, 2 names, 2 people. Okay, 3. Good. Okay. So you can get sued. People, you can get sued. You can get sued like everybody else can get sued, but you can get sued for your accountant, you know-ness, your ability to do paperwork and file proper numbers and things like that. Not only can you be sued by your clients, you can also be sued by who? Third parties who relied on your information in order to make a determination. So let's say, for example, that I have a business and I would like to sell my business, and I need to kind of have a valuation done of my business in order to ascertain what the value I'm going to attribute it to is so I could sell it to a third party. I bring you in as the accountant. Hey, here's my, what is it called? Receipts and receivables or something in receivables, whatever that term is. I tell you, I give you all my receipts. I give you all my numbers. Hey, tell me, what is my business worth? And you do your mathematical genius stuff and you tell me, all right, your business is actually valued at $850,000. Okay, great. So I sell my business to somebody else based on this valuation who buys my business for 800,000, 850, close to that ballpark. Now they get in. They buy the business for that price, and then lo and behold, they're looking at the numbers, they're looking at the receipts, and they say, oh shooey, this business is actually worth, you know, $500,000. But I relied on you, third party person. I relied on you, accountant, your papers in order to come up with my value. You could be sued. Now, again, if I was buying a business, I'm going to get my own people to obviously check the numbers. But the reason I give you this example is so you can be aware that you can be sued for these things. You know, some people do their own taxes, right? You know, TurboTax and I don't know, whatever else is out there. I don't. And I used to when I had nothing, right? But once I start having just a tiny bit, I have an accountant who does it. Why? Because then there's somebody who is liable, right? I need you to know what the law is with respect to accountants, tax liability, etc. Now, you as the accountant, if I try to sue you based on, you know, whatever the numbers that you gave me or the liability that you said that I owed, what is your out? What can you use to safeguard yourself, to protect yourself?
It's not my responsibility, it's my accountant's.
Right, but I want you now to pretend to be the accountant. If you're the accountant, I'm about to sue you for, not recognizing that I owed less or I owed more to the IRS, and now they're coming after me for, interest and penalties. Nicholas Gazzello.
You can put yourself behind a business so they can't go after your house and your car.
Good. You want to actually have a business to shield you, an LLC or a corporation or something like that. What else can you do? Lutram.
I was gonna mention what Letitia mentioned about the waiver, because usually if you don't have no type of paperwork saying, you're not liable for this and that, for like paperwork wise, because people can mess up. It sucks to say that, but we're not robots. At the end of the day, you gotta cover your butt with the paperwork that you have.
Absolutely. What you should do as an accountant always, and my guy does it, and I totally respect that. What you need to do is you say, I'm preparing this filing based on the information you are giving me. Okay? Because if they forgot to give you something, your client, and your numbers are off, well, that's on what? That's on them. That's not on you. So you always want to kind of put that out there, that you're not going to be the end all be all. They give you the numbers, they give you the receipts, they make representations to you, and then you do the paperwork based on that. Okay, so that's really only the stuff that I want you to know about accountants' legal liability, this particular chapter in your textbook. I'm going to move right along now to chapter 8. So we got to do chapter 8 and chapter 47 tonight. Okay. La-di-da-di-da, go back to my notes. Okay. So also fraud, I just want to mention that is a more of a listening thing also. If you commit fraud on paper, you can also obviously be sued. So it's not just a mistake with negligence. Fraud, if you lie on papers, like the Madoff thing, like they totally fabricated documents. And if you've ever watched American Greed, has anybody ever watched American Greed? Because I discovered that show a couple of years ago and I love that show. And that's why I don't like to give my money to anyone for investment. I rather invest the money myself and get screwed, because every stock I buy goes down. If you want a stock to go down, tell me about it, and as soon as I buy it, it goes down. But I rather make those mistakes myself than give it to somebody else. Flash flood warning. I can't shut it off. Oh, okay. I can't. There's no silence here. Sorry. Okay. You can't, fabricating documents is a no-no, right? That's absolutely, you're not only are you going to have civil liability against you, but there's going to be criminal liability against you. Okay. Well, what else do I have here for you guys? Okay. Now we're going to get into negligence, as a general tort. When we talk about negligence, we talk about, an unreasonable risk of harm. And so the court or the law always asks, was this reasonable? Was this activity that's going to have a particular effect or a particular impact? We always have, whenever we talk about negligence, those 5 elements again: duty, breach, actual cause, proximate cause, and damages. What I'm going to throw into the mix now when we talk about negligence is the reasonable person. You need to know this for the exam. This is like a topic I would like to say I always test on. The reasonable person is basically the perfect person. They make no mistakes. When we talk about the reasonable person standard, it's what the law or the court compares every plaintiff defendant to. They compare them to this perfect person. So if there was a car accident and there's a comparison being made with the driver or the person who got hit, the law looks and says, would the reasonable person have been traveling at 90 miles an hour when the speed limit was 45? The reasonable person would not have been, because the reasonable person follows the law and holds the wheel at 10 and 2 and looks both ways before crossing, or all that good stuff. So the reasonable person is the perfect person. And it's a person who's under a duty at all times to all others to exercise reasonable care for others, whether or not that person is on their property or in their purview. When we also talk about the reasonable person, we have different categories of the reasonable person. So I want you to know that the reasonable person equals the perfect person, right? That's who you're going to be compared to. But within the reasonable person, there's actually different categories. So I'm going to go over the categories with you now. And again, this is a topic I do want you to know. So minors are their own category. So children under the age of 18 is a category of a reasonable person. So if you have a case where a child was playing baseball, they hit the ball with the bat and the bat hit, a car and broke their window, and now the owner of the car is suing that child and their family, that person who hit the ball is going to be compared to a perfect child. Same category. Would a perfect child have been hitting the ball towards cars? They're not going to be compared to an adult. They're going to be compared to somebody of the same age, same intelligence, same experience, same, living conditions. So if you have somebody that lives in New York City, in Brooklyn, you want to be able to compare them to somebody that lives also in a metropolis type area, right? You're not going to compare them to a perfect little child who lives in, like Idaho, where there's like a ton of land and there's no people around or something, or like upstate New York, there's no people, you just see land, right? So you compare them to a child, same age, intelligence, and experience. That generally happens with most activities. However, if the person on trial, right, or in a case or in a hearing, that our defendant, our respondent, whatever it may be, is actually engaging in risky or adult-like behavior, then they're no longer going to be compared to another child. They're going to be compared to an adult, because a child should not be engaging in adult-like behavior. So if you have a child who commits murder, are they going to be compared to another child? Children are not supposed to be committing murder. They're not supposed to be having access to weapons. So a child may be then compared to an adult, tried as an adult, as opposed to a minor. If you have somebody who's 13 years old and took a car out and hit somebody, are they going to be compared to a perfect 13-year-old who takes out a car? There's no way a 13-year-old kid, a perfect one, is going to take out a car when they're not supposed to, right? So when you have risky behavior or adult-like behavior, then that whole comparison kind of goes out the window. Now you're comparing that child to an adult who's now going to be charged as an adult. The next category is the disability category. When you have somebody under a physical disability, somebody was crossing the street, and that person who was crossing the street who ended up getting hit by a car, they only had one leg and they were on crutches. So they were crossing, and they were crossing at their particular speed. They say it wasn't my fault that the car came speeding and hit me. Well, again, when the court does their analysis, that person who's crossing the street is going to be compared to another person crossing the street with the same physical disability, not somebody with both their legs who was able to speed walk, because maybe the car driver is saying, well, this guy was going so slow, I couldn't stop my car in the nick of time. No, when you have somebody with a physical disability, an arm, or, whatever it may be, they're going to be compared to somebody with the same physical disability. When we, however, and this is the big one now, this is the big differentiation, when we talk about somebody with a mental disability, and that person is on trial for whatever reason, unfortunately, the law has not caught up. And a person with a mental disability is going to get compared to a person of average intelligence, that perfect person we spoke about in the beginning, which is a completely unfair thing. The law, the courts, society has not yet acknowledged, caught up with mental illness as much. And so you could plead, if it was a criminal area, you could say you can plead insanity. You usually plea out, in general. But the fact that you had a mental disability is not enough to kind of get you off the hook. And I will tell you that I work right now, I'm the supervisor of the guardianship department, right? And so what happens is I deal with families and organizations that are in tune with the disability community. And I've learned a tremendous amount over the past 2 years, 2.5 years or so. And it's heartbreaking because the statute that governs us, surrogates court, with respect to disability, used to refer to people as mentally retarded. It was only changed to intellectual disability a couple of years ago, less than 5 years ago, right? We're in 2021. And it took that long for just the language to be changed, okay? So again, somebody with a mental disability is going to be compared to the reasonable person, not somebody with that same mental disability. The last category of the reasonable person is somebody who has superior skill or knowledge. So a doctor is going to be compared to another doctor. An attorney is going to be compared to another attorney. An accountant is going to be compared to another accountant. Somebody with a special skill or knowledge is going to be compared to another person with that same skill or knowledge. Okay. Does anybody have any questions about this stuff before I move on to the next area? Okay. Okay. Next case that Nicholas, you had a hand up, but it went back down. I don't know if that was.
Yeah. Sorry. No, it's just because the Wi-Fi kind of cuts out. So like if I raise my hand, it doesn't go until like 3 seconds later sometimes. That's why.
Okay.
Yeah. But I was just going to say, like, the reasonable person is just like an archetype for the law to compare to. And then it's just based on what kind of person is, like, it's based on the defendant that's trying to make his case, his or her case.
Correct.
Okay.
Yeah.
All right.
It could be not just the defendant, it could also be the plaintiff, but usually the defendant, because the plaintiff is, would the plaintiff have because don't forget there's also defenses to certain actions that are being done, and sometimes the burden of proof shifts between one side to the other. And so that perfect person is really just a comparative to everyone. Would perfect people have reacted in that particular way? It sets a standard.
Okay.
Okay. Liam, I see your hand is up.
Yeah, so I have a question about the reasonable person comparisons.
Sure.
So just because I work with people with developmental disabilities, it's just something I'm curious about. Is it like, so if someone with a developmental disability commits this crime or does something, someone's suing them, is it a rule within the law system that they have to be compared to someone who the reasonable person who doesn't have a developmental disability, or is it?
So it's not a rule, it's just the default because there's no category to compare them to somebody with that similar disability. So if there's a crime that's committed, look, in real life, would an ADA prosecute that person? I don't know. Because when you have the family of the victim, they don't care whether or not somebody is under, a developmental intellectual disability. What if it's also a disability, like autism or ADHD or something like that? And, some people could say, oh, well, it could be controlled with medicine or could be controlled with this. The law and society have not really delved into this area of law to see the unfair implications of persons with developmental and intellectual disability. And now I also have to ask, where do you work, or like, what do you do?
Well, I work for AHRC, is the company.
HRC.
The Melissa Reggio program. It's at CSI.
Interesting. Do you work with? Oh, I don't know if Donnie Swanson is over there. I think he might be a different school. Very interesting. You know what? Reach out to me. I know that CSI does have a big program, and I actually refer to I refer people there. Do me a favor, send me an email to my Gmail.
Sure.
Because I want to see how we could help people over there.
Sure.
Okay.
Will do.
All right. Anybody other questions before I move on to the next topic? Because today we're going to probably go for a long time. So I want to make sure we get through our material. Okay. Okay. So who wants to tell us about the case of Ryan versus Freisenhahn? Nicholas, go ahead.
It's about a girl that went to a party, like a bring your own beer party, and she went home driving and died. And I think it was the family of the girl sued the party for knowing that it was going to be she was underage drinking there.
Correct. Excellent. You mentioned underage, and you mentioned that her family sued the host family. Now, there was some back and forth in the courts with this particular case, because originally, they sued not the party, the family, the parents of the host. And there is a thing in the law or in that particular state that said, well, you know what, each person is responsible for their own actions. So if that person, became intoxicated and they left and they got behind the wheel, that's on them. However, the kicker in this case, or what made the outcome favorable to the victim's family, was that a young person under the age should what? Should not be engaging in that type of behavior. And so the host's family knew that their son was having this party and knew that this was going to be happening. And so by them knowing this and not stopping it, they actually incurred liability. Right? Because a child, right, a minor, we said, is not supposed to be engaging in adult-like behavior. And that's what that was. Make sense? Anyone? Yes? No? Okay. I'm going to.
Yeah.
Okay. Thank you.
Yeah.
Thank you. Thank you. Thank you. Thank you. Good. All right. So that is Ryan versus Freisenhahn. Good. Good, Nicholas. Okay. We're now going to go over, those like 5 elements, right? So now I told you I'm going to go over them into a little bit more detail. So now we're going to do that. So first is duty. When we talk about duty, again, it's like a general rule or a general theory of the law that a person has a duty to all others at all times to exercise reasonable care. At all times, right? However, but there's no duty that exists when there's a risk that's created. Forget that last part. Just think about the different duties of people that interrelate with one another. And within that, remember I said, like, if you're driving, you have a duty to everybody on the road, right? There's always duties of people to one another, but there's also special relationships that exist where there's an automatic duty, like automatic duty. So this is not stuff you have to like memorize. So this is just stuff me giving you examples so you can understand the whole concept of this. When we talk about special relationships, it's common carriers with passengers. What does that mean? Bus drivers, train operators, ferry operators, to the people that they're carrying and moving from place to place. They have a duty to, be vigilant and aware of what's going on. There's this case that my son, actually, my 8-year-old, taught me, because he's very much into ships and boats and cruises and history and stuff like that. And it was, I believe it was the Costa Concordia, where, what was the captain's name? Francesco Schettino. And the Costa Concordia, a Carnival ship, right?
Costa, which it was actually owned by Carnival.
Okay, so this ship, anyway, it hit some rocks, right? It was kind of near the coast, so there wasn't it wasn't like a Titanic thing. But the captain, number one, was not doing what he was supposed to be doing. He was, I know where he was. Okay, fine, just go quick.
So he had brought someone aboard with him with free tickets, and they were talking to each other.
A lady friend, but they were talking to each other. Okay, guys.
And he was distracting him.
she was distracting him. And so the captain was not aware of what's happening. And then, so the ship hit these rocks on the bottom. The ship started to go under, and then the captain left the ship and he left. So then they were like, the people on, you know, and I don't know, headquarters were like, Captain, did you just leave the ship when you have passengers on board? And he was not going back to that ship. He was like not going back, and people died. There's people that died, right? 32 people that died on that ship. Abandonment. Thank you. He abandoned his ship. He was actually tried for a multitude of different things. And he served a prison sentence because a captain, a driver, common carrier, whatever, have a duty to their passengers. That's the first one. Second one, innkeeper with guests. That's the hotel, motel. I don't know. I wonder if Airbnb is considered really innkeeper. I don't think so. But, you know, hotels and motels, establishments like that, they have a duty to their guests. Employers and employees, schools and students, landlord and tenants when it comes to common areas, businesses open to the public. They have to make sure that it's safe for people to enter, and parents to children. So as a parent, I have to make sure my kids are, you know, alive, well protected, and things of that sort, special relationships. Well, with that being said, so this next case is about duty, right? So who wants to tell us about Soldano versus O'Daniels? It's a fun case. Anybody besides Nicholas? Okay, Nicholas, go for it.
So someone got shot in a bar, and someone ran out to another bar to ask for the phone, and the bartender said no. So they're trying to try the bartender for not giving up the phone to call the cops.
And what did the court say?
That
You remember?
it wasn't the bartender's fault for not giving up the phone. He didn't need to do that.
Was that appealed? What was the ultimate outcome? Do you remember?
No, I don't. If that's
Okay.
wrong.
No. You did very good. In this particular case, if I remember correctly, the actual issue was that to give somebody the phone. Okay, Jessica, you have a hand up. Go ahead.
It was so they decided that he didn't have to call 911, but the problem was that he prevented somebody else from calling 911 using a public phone in a restaurant that was open to the public at the time.
Exactly. So he didn't have to do it, but he prevented somebody from taking such a small act. Like if you just given him the phone, they could have saved somebody's life. So that was the issue in this particular case. So Nicholas, good job. Jessica, good job. Together you have the whole package here. So you can't, especially because it was a business, it wasn't a private entity that was like, oh, I don't want to get involved, you know, leave me alone, close the door. It was an open establishment. So when it's an establishment like that, a business, it is open for other people. Good job, guys. Good job. All right, moving right along. Okay. Okay, this is a quick thing when it comes to land duties and possessors of land. So there's different relationships of people to land. So if you've ever seen like a trespass sign, it means like you can't go on somebody's property because then you'd be trespassing. And so if there's a sign that says don't go there, do not enter this piece of property, you'd be trespassing, and then you go there and then you get hurt, you can't recover because there was a sign that says do not enter, do not go. When we have areas, there's certain classifications of people, like if somebody goes to my home and they get hurt in my home, I'm going to be responsible because I invited them into my home. When it comes to a public place, they're always going to be on the hook because they're invitees. So they, by virtue of them being a public establishment, they're inviting people and come on in, people coming in. So if they slip and fall, if they get hurt, if something happens, then that organization or that entity is going to be a problem. This next case, I always test on because I think it's so fun. Love versus Hardee's Food Systems. Who wants to tell us about that one? Fadi, good. Tell us.
So a little boy and his mother went to the restaurant in Missouri, I think it was,
Mm-hmm.
and there was construction workers that were working there, and there was water on the floor in the bathroom, and they didn't leave a wet floor sign, and the kid slipped and fell.
It wasn't a kid, it was an adult. It wasn't a
Oh,
minor.
adult? Oh, I was saying
Yeah.
him and his mother, so that was a
Oh.
child, and he had to undergo, I think, 2 back surgeries,
Mm-hmm.
and the person that was in charge of like the bathroom maintenance was supposed to work till 3, and they left at 1, I think, so they didn't know if he did the maintenance at that time or not.
Mm-hmm. Very good. Do you remember anything else about this case? Like the record
No, I
keeping?
don't remember.
Okay.
No, that part I skipped it.
Okay, good. You did good. You basically got it. It's a slip and fall in a bathroom. It is a restaurant. Does anybody else remember any of the other facts that Fatty, do you remember if this person recovered any money in a lawsuit?
No, I don't remember because I
Okay.
read it a couple days ago.
Okay. All right. Does anybody else remember whether or not this person recovered? Nicholas.
He got any money that he lost from missing work because he, due to the surgeries, he missed a lot of work. So he got all the money he lost from not working.
Okay. Did he recover anything else? Jessica.
$125,000.
Correct. He also received $125,000 as compensation. Now, one of the facts, remember I told you in the beginning of the semester, facts are extremely important. So they, in determining whether or not this person was going to recover money for a slip and fall in a bathroom, they looked at the facts. The restaurant was not busy. Okay, there wasn't a lot of people there. The bathroom, the water had been there in the bathroom for quite some time. They're supposed to keep a log of who cleans it, and mysteriously, like the logs disappeared or something. Like they didn't have people that cleaned it when they were supposed to. So the reason I like to test on this case and I like to emphasize this case is if you were to go to a grocery store and you were to slip and fall on something, just because you slip and fall and get injured doesn't mean you're going to automatically recover money regardless of how severe the injuries was. Why? Because was the establishment aware of the negligent behavior and did they have a chance to remedy it? If you go to like a ShopRite, Stop and Shop, any of those places, as soon as, something happens, a spill, they call it spill in aisle, blah, 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 maintenance to clean it up. Why? Because they have a certain period of time to clean it up to prevent somebody from getting hurt and ensuing. But if an incident happened, right? Like, somebody, I'm in the sauce aisle and somebody picked up a jar of sauce and they dropped it and it fell and I wasn't paying attention and I went and I fell and I slipped and I got hurt. I don't know that I would necessarily be successful in recovering. Why? Because the defense of the supermarket was going to say they did not have the opportunity to clean it up, right? Whereas in this particular situation, they had plenty of time. I mean, that water was in the bathroom floor for hours and they just neglected to do it. Fatty, the little yellow hand is still up. So I don't know if you have another question or if you just from earlier.
Yeah, I forgot to put it down, my bad.
Okay, no worries. Okay, good job, guys. Good job. We're doing good today. Doing good. Okay, this next concept. Remember, sometimes I like to tell you, okay, you can impress your friends if you talk to them in Latin, because I'm sure that's what everybody does in their spare time. This next concept is a Latin legal concept, and it's called res ipsa loquitur. I don't remember. I don't know if I'm going to test on it or not, but I think it's a lot of fun, and I'm going to put it in your chat. Res ipsa loquitur is a Latin legal concept that basically says the thing speaks for itself. Sometimes words are not enough or they won't do it justice. By virtue of the situation, it's just, it is what it is kind of thing. So res ipsa loquitur means the thing speaks for itself. Okay, which brings us into causation, factual cause and proximate cause. So again, when we talk about actual cause, it's the factual cause. It's the conduct that caused the harm, right? Good. proximate cause is that difficult concept. Let's just go straight to the case, because once I explain the case, you're going to really just, it's going to click. Who wants to tell us about Paul's Graph versus Long Island Railroad? I want you to know that this is the case. Paul's Graph versus Long Island Railroad. This is the case that is taught in law schools all over the country to explain the concept of proximate cause. I remember learning about this case when I was in law school. We actually had a class, an entire semester dedicated to torts, the stuff that I'm talking about like today. We had an entire semester on it. So who wants to tell us about Paul's Graph versus Long Island Railroad? I always test on it. It's an awesome case. It's a lot of fun. It's crazy. It's crazy. Anyone? Compton, yes, tell us.
Yeah, so it was this lady, Mrs. Paul Graff. She was buying a ticket at the train station, and the train has a train that was already stopped was about to depart, and these two guys were trying to catch it. So when the first guy got on the train, but the second one, he almost didn't make it. But I'm assuming that one of the train conductors helped him on from in the train, grabbed his hand, and somebody on the platform, I guess another conductor, was pushing him from behind. And while they was assisting him as getting on the train, they knocked the package out of his hand, and the package that was knocked out of his hand ended up on the train tracks, which contained fireworks. So the fireworks exploded, and it injured the lady that was buying a ticket, which is Mrs. Paulgraff. And Mrs. Paulgraff went for a suit against the railroad, but for some reason they overturned her judgment or her claim.
She didn't win
because they won't have no duty for the fireworks, basically. Like
right.
That's not their fault.
Exactly. It was not foreseeable, right? So as Compton was talking about this case, right? Let me say it again. Let me say it again, because it's just such a fascinating case. You have this woman, right, buying a ticket on one side of the railroad, right? So she's on, imagine if you've been on the trains, right? She's on one side going somewhere. On the other side of the train track, you have these two guys trying to get in. One of them gets in, and then the other guy, he's not able to get in. The guy from the railroad's pushing him on so he can get in. He drops a package that has dynamite, right? Or like fireworks, right? Fireworks. It hits the train track, makes an explosion, which causes a scale on the other side of the railroad to fall on top of Mrs. Paulgraff and injure her. In your wildest dreams, would you have thought that how Mrs. Paulgraff was going to get hurt when the story was being told by Compton?
No.
No way in hell, right?
No, I didn't even know that.
Not even close. It's not foreseeable. It is not foreseeable. So if you don't have foreseeability, you're not going to be able to collect. Is it foreseeable that a doctor could operate on the wrong leg? Yes, it's foreseeable. Is it foreseeable that somebody would be carrying fireworks on the train tracks that are going to hit the railroad, that are going to cause an explosion to make a scale on the other side of the railroad fall and hit a little old lady? Not foreseeable. Not foreseeable. Lutram.
I have a question. Is it possible that case could happen if she sued the people who had the fireworks?
Exactly. If she had sued the person who carried the fireworks, she would have had a much better case, because the person carrying the fireworks has an expectation, or it's reasonable or foreseeable to be able to tell that somebody carrying fireworks, that thing is going to explode and cause an injury somehow. She went after the wrong party. So therefore, when you sue, you have to sue everyone involved in order to be able to collect.
Yeah.
Nicholas.
wouldn't her lawyer like have the knowledge to do that, to sue the right person? Like, I don't understand like how you messed that part up.
Listen, so here's a theory. Number one, I'm going to tell you something, and I'm an attorney myself, right? Don't think all attorneys are like, not to say anything about Eddie Della Pioli, but don't think, don't think all attorneys know what they're doing. Okay. Some attorneys suck essentially, but they're all going to take a lot of money. And sometimes the judgment call would be, listen, we're going to go with the person with the deepest pockets. So maybe that person that was carrying the fireworks has no money. So even if they sued and they recovered, Mrs. Paulsgraf recovered, she wasn't going to be able to collect anything because that guy has no money, has no assets. So they go over the big, the person who has the most money, the deepest pockets, in order to try to collect something. But again, if the liability is not there, you're not going to be able to collect. Lutram.
Yeah, I don't know why, but I heard this case of this guy suing his landlord, and the landlord wouldn't pay for like the whole thing. Like, I guess what was this, 1,800? So the court forced them to do like a monthly, I guess, payment plan on the guy that's suing the landlord. That's why I was like, why didn't the lawyer just think of that on the people that don't have money? They
This
have to
case is
have
an
a
older
job.
case. Look,
Yeah.
this is an older case too.
Oh.
So, theories in the law changed. I mean, this is the case that is the example now for proximate cause, right? Before that case, I don't even know what cases there were about. This is proximate cause. So, the law gets creative also sometimes. And as time and years go by, people use cases precedent to create new law. So
what if hypothetically that case just disappears? Like, would
I don't know. I mean, there's a lot of cases now that hinge upon that particular case.
Yeah, because right now there's a case of abortion right now. I forgot what the case was called. I remember I read about it. It's like Roe versus Wade.
Roe v. Wade, yeah. Roe v.
They're
Wade.
thinking of, changing
Overturning it.
Yeah, so I was like, what if that situation happened over here? I'm like, what would be the outcome?
So what would happen? So on a case that's set precedent, right? Roe v. Wade is very different than Paulsgraf, because Paulsgraf set a particular area in negligence law about whether or not that particular duty exists. Roe v. Wade would change the law to now just say abortion at this particular time is illegal. And so any, from if it is overturned, then any cases of abortion or incidences of that would and result in legal ramifications or criminal ramifications for people. So there are cases that go up before the Supreme Court of the United States of America that can change the outcome of how we live our lives. So there was a whole thing about the Medicare for all, the Obamacare. I think that was affirmed, and there are case law that really affect people's lives, but I'm not going to get into that now because it's after 8:00 and we still have a bunch of things that we got to go over. All right. Does anybody have any questions? Does everybody understand now the theory of proximate cause? Is it clearer now?
Yes. Yes.
Excellent. Good. Okay. The little person also just woke up, so I'm gonna move a little faster because I don't know how long he's gonna give me of quiet time. Okay. Damages we kind of talked about, so you already know what damages are. So when we remember, like last week, we talked about criminal law and then we talked about the defenses. We're gonna now talk about defenses to negligence. Just take a look at the syllabus. Okay, we're doing good. Negligence, when we talk about defenses. So sometimes if you're suing someone and they're able to prove those 5 elements, the duty, breach, actual cause, proximate cause, damages, the tables turn now. All right, well, now plaintiff should recover. The defendant can say, well, plaintiff contributed to the accident, right? The plaintiff contributed to the problem at fault by their action. So there's a theory in the law called contributory negligence, which says that the person suing contributed to the accident themselves. So let's say you have a car accident and you have a car that was speeding, good morning, and hit a pedestrian. Well, the car driver can say, well, the pedestrian wasn't crossing in the crosswalk. If they had been crossing in the crosswalk, I would have, instead of the middle of the street, I would have had ample opportunity to stop. It's not, but you can have it. So if they had done that, then I wouldn't have hit them. I would have been able to stop. And so they're contributory negligence. And what happens is, let's say a jury was going to find that the person who was speeding was in fact wrong, you know, that they hit this person and they assess $100,000 worth of damages. If they find the other side, okay. If they were to find that the other person was contributory negligent and they attribute them to be 20% negligent because they crossed in the middle of the street rather than in the crosswalk, then what's going to happen to the ultimate recovery? Instead of 100,000, you know what the defendant's going to get? I used easy numbers for you guys. They'll get $80,000, right? Because the jury says, okay, they're $100,000, you know, but because that person crossing in the crosswalk should have been crossing somewhere else. The plaintiff or the person, the car driver was speeding. They were in fact speeding. And that was a major part of the problem here. But if that person that was walking, if they had actually crossed in the crosswalk, they wouldn't have gotten hit. Well, they're 20% negligent. So then the ultimate recovery would be 80,000 instead of the 100,000. So contributory negligence is a defense and it can be used to lower the ultimate outcome, sometimes eliminate it even completely. So that's one defense. Assumption of risk. Assumption of risk is sometimes things happen. But if you've engaged in a particularly dangerous activity, even if there is liability or even if you had a potential chance of a lawsuit, it might not happen because of the nature of the activity. So this is the example I always give because I think it's the easiest one for explanation purposes. Has anybody here ever gone skydiving? Oh, that's nice. No. I've never, and I'm not going to, it's not, you know. Okay, has anybody here ever wrestled with wild animals? No. Okay, has anybody here ever gone drag racing? Say no.
Yes.
Yes, okay. So maybe, okay. So for the people who have engaged in that type of behavior, if an incident happens, are you going to be able to say that anybody else was contributory negligent to your, you know, accident or whatnot?
Professor, can you repeat that question?
Sure. The point I'm getting at, and it's a lot easier to do with like skydiving, but when you engage in very risky behavior, you waive your right to sue and recover, right? So if you've ever gone skydiving, or for the people that done the drag racing or anything extremely dangerous, you're basically waiving your right to sue and recover assets if you're injured. Why? Because you're engaging in risky behavior. You're assuming the risk of injury and you're saying, I don't care. So for those who have ever gone, nobody here has gone skydiving, they make you sign a whole bunch of forms that say, even if you die, they're not going to be at fault. You are saying even your estate cannot sue them because you're engaging in this type of behavior, that's on you. If you've engaged in I think like, speed car racing, you're probably going to be, signing off all these waivers as well. Brian, zip lining, good one. Brian, go ahead.
When I went parasailing, like a few years back, they made me sign that form.
Exactly. You're signing all these waivers and you're saying, regardless of what happens to me, the chute can break, the chute can fall, I could die, I could break a leg, I could be maimed for life, but I'm totally okay with that. And I'm still going to do, go ahead with this thing. Nobody reads that stuff. They just sign so they can go parasailing or skydiving or whatever it is. I've gone parasailing in my life once. It wasn't that so bad. I don't think you're going to die from it, although people can. But what about, there's some behaviors that are not even that risky, like skiing, right? And people die from that. But when you're doing that type of behavior, you're not necessarily signing any waivers saying that if something happens to you, you're gonna you're not gonna sue anyone. So just keep that in mind. Risky behavior essentially voids any remedy that you could have in the law. Okay. Next. Okay. Next case, I think this is on your syllabus, is Palumbo v. Newkirk. Let me just make sure that's on there. Okay, who wants to tell us about Palumbo v. Newkirk? That's the last case in this chapter before we do property.
I'll go, Professor.
Go ahead.
So Palumbo was basically a mail carrier. I believe like he was delivering mail, and in that process, the other person, I believe Nykirk, like the homeowner, their dog bit and attacked Palumbo, who was the mailman, and he got injuries. He sustained injuries from that. So I believe the mailman said that like he didn't see the dog there until he opened the mailbox. Like I believe there's something in the way, like a bush or like something blocking it. And then Nykirk, who was a homeowner, was basically saying that like his dog never reacted that way before, and that's not his normal behavior. So yeah, that's kind of what I know about it.
Okay, very good. So was there ultimately a recovery for the dog bite?
I believe no, but I think it went in Nykirk's way.
The homeowner essentially won. Why? Because it was a domesticated animal that did not have any history of violence. So basically, if you have a dog, I don't want to say you get like one free bite. Your dog will get one free bite of another, person or human or injury of some sort, but that's pretty much it, because there's no propensity for dangerousness. And so even if a dog or an animal, a domesticated animal, causes injury to somebody else, you're not going to have to fork over any money because it's their first time doing it. So you had no way of knowing. However, if you are housing a wild animal on your premises, like a tiger, for instance, there is no freebie because you're housing a wild animal. So whatever it is that they do to injure another person, you're going to be responsible for that. Okay. So that is that. Now I'm looking actually, does anybody have any questions on any of the stuff that we covered so far? Okay, great. How are you guys doing? Alive and well? Okay.
Wait, question.
Go ahead.
Can you go over again the difference between contributory and comparative negligence?
I actually just kind of talked about it real quick. It's usually when I test you, I'm not going to ask you about the different type of principles. Comparative negligence is when you can assign a percentage allocation of fault to each party. Comparative, you're comparing the fault of each one. And sometimes, depending on the state that you're in, if the person suing was to be found to have more than 50% of the fault, they won't recover anything, even if there was injury sustained. And if it's more than 50%, they're not going to get anything at all. So comparative and contributory negligence are just ways to assess and attribute fault in a financial or percentage wise to the complaining party. It's a way to lessen the amount of money that's going to have to be paid by the defendant to the plaintiff. Hold on one second. Hold on.
Okay.
Okay. Give me a minute. Okay. Does anybody else have any questions on this stuff? Because I'm looking at the chapter syllabus, and actually chapter 47 deals with property. So it's all about like kinds of property. And so chapter 47 and chapter 48 and 49 are all about property. So it will make sense if we talk about it all at once. So next week is not so bad as far as, it's only 3 chapters next week. So I'm going to add chapter 47 to next week. And then we're going to talk about 47, 48, 49, and 50. Just so you're aware, next, I don't know if it's next week. What's the syllabus say?
Yeah, are you meeting next week? That was my question.
No, actually, whoa. Wow, I'm not going to see you guys for like forever, not until September 22nd, it looks like. So September 22nd, I don't think we're meeting at all. Yeah, next week we're not meeting because it's Labor Day. I just gave my 4-year-old my phone. So I think, yes, Letitia, the next time we meet is September 22nd, according to the syllabus. So there might be some holidays or something. And then after September 22nd is it's our first exam. So the material that we're going to cover next time we meet, which is chapters 47, 48, 49, and 50, will be the last of the material that is going to be on your first exam. So everything we've talked about so far, plus those 4 chapters. And so I'll definitely have time to post this video and the first video up of on YouTube and then on Blackboard. Does anybody have any questions about any of the material that we discussed so far tonight? Jessica, go ahead.
In the case of Palumbo versus Nickkirk, is the burden on the dog owner to prove that the dog had no history of
Shift. No, the burden is always on the person suing. So the person suing is the plaintiff, and it would be the person that received the injuries. And so they have to prove those 5 elements. The defense then, right? So once they prove, duty, breach, actual cause, proximate cause, damages, then the duty shifts to the defendant, which is now the owner of the dog, to say, well, this was the first time. I had no idea of this happening. And then it kind of shifts it back. And so then that's why the plaintiff wouldn't recover.
Okay, thank you.
You're welcome. That's like totally in the law, by the way, that burden shifting. You have to start with one, and then if they prove their elements, then it goes to the other side. It's like, the defense is kind of back and forth. But you don't need to know this for this, this class, just life. Does anybody else have any other questions? It also appears that we had a couple of people came in after I took attendance. So if you were not here when I called attendance and you want to hang out, just kind of let me know who you are. That way I can mark you present for today so you can get credit, then that's fine. Otherwise, all have a great evening. Enjoy the next couple of weeks. Don't forget everything you've learned in this class, and hopefully stay dry.
Thank you, Professor.
You're welcome. Good night. Good night, everyone.
Have a good night, Professor.
Good night. Good night. Nicholas, I see your hand up.
Thank you, Professor.
Yeah, I have a general question, but if anybody wants to say anything before I ask, because I guess it's kind of a long question, so I don't want to take no time from anybody.
I think people are logging off already, but
all right.
So you can ask.
It's just a question about the textbook, because I ordered the textbook from this website. I think it was A Books. It's usually where I get a lot of my textbooks, are just the stuff that I like to read. And when I got it, it was like badly damaged, so I had to get a refund for the money. So I ordered that the day of a first class, and I did the same day shipping. So I actually got it Friday, but I had to send it back because it was badly damaged. So I was wondering if you could provide an ebook link, or you said I could get it from the CSI online store. But
the online store should have it.
Is it a physical copy, or is it an e-textbook?
I know that there's students in the past who have gotten the ebook because they'd ask me and I'm like, yeah, that's fine. Whatever you can get of this book, whichever, edition that you can get is fine.
Because I just need something quick to read because I got to catch up on the
Compton just put a link in here to
okay.
you.
All right, thank you. Yeah, because
Thank you, Compton.
I have to catch up on the stuff to read, and I hate being behind.
Okay, no, then you can go for that. People are talking about that has all the books for free to download. Oh, that's very good to know. Excellent. That's good stuff. Muhammad, you have a hand up.
Yeah, Professor, I had a question about something we did earlier in the night. So, about accounting, you were saying how your accountant said that basically there's certain things that basically what he told you was that he goes off of the numbers that you give him. So in a way, he's kind of protecting himself.
Correct.
So if your accountant does that, do they have to give you that in writing, or they can just say
It's always
verbally?
no, definitely. You should never do anything verbally. And by the way, we're going to talk about that, all the contractual stuff when we get into contracts, which is the second portion of this class. Always do everything in writing. There's a paper like that he gives me to fill out, and he gives me like a whole packet that he emails, and it's questions I have to answer. And in there, it always says that first page, he's basing his return of my drafts based on the information I give him. Not only that, but he gives me the draft to review to make sure that I check off that I say everything is correct before he actually files.
Okay. Does he give you that at the end of the year when you're filing your taxes, or is that in the beginning when you guys first start doing business?
It's whenever I contact him, so we could it's like, hey, listen, it's time for us to do taxes. He'll send me the package for that, and then it has it. So every year I get it.
Okay, thank you. This is my first year with an accountant, so I'm guessing like at the end of the year, he's gonna give me that. So I'm definitely gonna read through it. I know it
Whenever
varies
he's
from
about to
accountant, but
file, he should give you something in writing. If it's somebody that's legitimate, they'll give you something because they want to protect themselves from liability. So
okay, makes sense. All right, that was my question. Thank you.
Okay, you're welcome.
Yeah, Professor, earlier you mentioned you wanted me to email you. I don't see your email on this. Is it on the syllabus?
It should be on the syllabus. I think it's on the last page, but that's only my CSI. Let me give you, I put my Gmail in the chat. Let me put it again in the chat now. Hold on. La-di-da-di-da. I'm going to give you 2 email addresses. This is for really everybody, but it's Irini Bekhit at Gmail, and then Bekhit at nycourts.gov. So if it's actually work related with the disability community, so you can email me at the nycourts.gov.
Okay, will do. Thank you, Professor. Have a good night.
You're welcome. Now, if I know you guys are all talking about all these group things and your numbers are being thrown out left and right. If I end this, are you still going to be able to